ಆಮೇಲೆ
ಅಲ್ಲ,
ಕೊಡ್ಲೇ
ಅದೇ
ಇಲ್ಲ
ಈಗ-
ಅಂತ ಏನ್ ಅನ್ಕೋಬೇಕು?
ಅಲ್ಲ, ಅವ್ರು
ಈ ತರ submission ಇರುವಾಗ
for the accused.
ಈಗ
CBI also was given. ಕೊಟ್ಟಿಲ್ವಾ ನಿಮ್ಗೆ?
ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಅಂತ ಹೇಳಿ
ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಅಲ್ಲ, ಸಾಹೇಬ್ರು ಕೇಳ್ತಾರೆ, ಪೆನ್ ಡ್ರೈವ್.
ಪೆಂಡ್ರೈವ್ ಕೊಟ್ಟಿದ್ದು.
ಮತ್ತೆ
ಗೊತ್ತಾಯ್ತು, ನಾನು ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಕೇಳಿದೆ. ನೀವು
ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಅಲ್ಲ,
ಫಸ್ಟ್ ಡೇ ಆಫರ್ ಮಾಡಿದ್ರು, ಆಮೇಲೆ ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಏನ್ ಅನ್ಕೋಬೇಕು?
ಅದ್ರ ಏನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ ಪೆನ್ ಡ್ರೈವ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಆಗತ್ತೆ ಅವಾಗ.
ಅಲ್ಲ
ಅಲ್ಲ, ಅದನ್ನ ವಿಡಿಯೋನ ಬೇಕಾದ್ರೆ ಪ್ಲೇ ಮಾಡ್ಬೋಣ ಅಂತ ಬೇಕಾದ್ರೆ
ಕರೆಕ್ಟ್, ಬಟ್ ದಟ್ ಶುಡ್ ಬಿ ದಿ ಫಸ್ಟ್ ಥಿಂಗ್ ಯು
ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
ಅಫಿಡವಿಟ್ ಜೊತೆಗೆ ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್
ಮಾಡ್ಬೇಕಾಗಿತ್ತು. ಮೇಲೆ ಲ್ಯಾಬ್ಸ್ ಆನ್ ಅವರ್ ಪಾರ್ಟ್.
ಎಸ್.
ಐ ಕ್ಯಾನ್ ಸಿ.
ರಿಪ್ಲೈ
ಏನ್ ಗ್ರೌಂಡ್ ಮಾಡೋದು?
ಬರ್ಲಿ.
ಇಲ್ಲೇ ಇದೆಯಲ್ಲ, ಇಟ್ ಬ್ಲಾಕ್ ಅಂಡ್ ವೈಟ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ, ಗ್ರೌಂಡ್ ಮಾಡೋದೇನ್ ಬಂತು?
ಇಲ್ಲ, ಪೆನ್ ಡ್ರೈವ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ.
ಅಲ್ಲಲ್ಲ, ಮೆಮೋದಲ್ಲೇ ಇದೆಯಲ್ಲ, ಏನಾಯ್ತು ಅಂತ ಅನ್ಬಿಟ್ಟು.
ಇದೆ.
ಮೆಮೋದಲ್ಲೇ ಇದೆ, ಏನಾಯ್ತು ಅಂತ ಅನ್ಬಿಟ್ಟು.
ಇಲ್ಲ, ಪೆನ್ ಡ್ರೈವ್ ಇದು ಬಂದಾಗ
ಮಾತ್ರ ಗೊತ್ತಿರತ್ತೆ
ಸರ್, ನಿಮಗೆ ಈಗ ಗೊತ್ತಾಯ್ತು. ಗೊತ್ತಾಯ್ತಲ್ಲ ಗುಡಿಯುಮಾರ್ ಸರಿ, ಈಗ ಗೊತ್ತಾಯ್ತಲ್ಲ ಏನಾಗಿದೆ ಅಂತ.
ಅವ್ರ ಮೇಲೆ ನನಗೆ
No. This honorable court and the Supreme Court has time and again come upon the parties heavily as and when even a tribunal is made a party. No, there is no need for you to make the tribunal a party. A Tahsildar is a party. A deputy commissioner is a party. It is a court that passes the order. No, when I seek for transfer of the case, you take it from me, I will certainly make use of it. In the event it is warranted, I will certainly make use of it. In the event of there being such a contingency, if not today, tomorrow, I do not know what is going to happen, how your lordship is going to react to this. I can't imagine to myself. Certainly I will do it. I am not hesitant. I am here, my lord, to invoke my lord's jurisdiction to see that justice is done to the parties in the case. That's it. But my suspicion is, if these two were to be kept in juxtaposition and dread, ಹಾಕ್ತೀನಿ. ಅವತ್ ನಾಗೇಂದ್ರ ನಾಯ್ಕ್ ನಮ್ಮ ಹತ್ರನೂ ಇದೆ ಅಂದ್ರು, ನಿಮ್ದು ಹಾಕ್ಬಿಡಿ ನಾನು ಅಂತಂದೆ. ಏನಿದ್ರೆ ನಿಮ್ದು ಹಾಕ್ಬಿಡಿ, ಎಲ್ರದು
ಏನಿದೆ ಕೊಟ್ಟು ಬಿಡ್ಲಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಇಟ್ಕೊಳ್ಳಿ. ಬಟ್
ಯಾರ ಜೊತೆ ಅದು ಕನ್ವರ್ಸೇಷನ್ ವಿತ್ ಅ ಲೇಡಿ?
ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 is speaking to the lady.
Yes, both of them go to Delhi. ಅದೇ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದು. ಯಾವ್ದನ್ನ? As a document, boarding pass and all that, tickets of boarding pass ಎಲ್ಲ.
Yes.
But what I am submitting to lordship is, why is it necessary for the purpose of adjudication of this application? Probably the next question would be from your lordship would be this. Well, look at his conduct. He is a blackmailer. He is trying to blackmail me. You are going to grant pardon to him despite the opposition by the victim, Malava, the wife of the deceased.
The whole thing is victim has opposed the application, saying that don't grant pardon.
Don't grant pardon.
she is a hostile witness in that state case.
Hostile
She
witness.
herself-
ಅಲ್ಲ, victim herself is trying to-
But she herself has not supported the case. We are
Yes,
not. Her husband has been done today.
Not against others, but against him.
against accused number 1.
Yes.
She has turned hostile against other.
But he's not treated, well, kindly see this.
Treated hostile.
ಯಾವುದೋ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಬಿಟ್ಟೋಗಿರುತ್ತೆ. If need be, I shall take your lordship to the evidence. That is what I am producing now before your lordship in the documents. ಒಂದು ಸೆಂಟೆನ್ಸ್ ಯಾವುದೋ ಒಂದು ಇರೋದಿಲ್ಲ. Did you identify him ಅಂತ ಏನೋ ಇರೋದಿಲ್ಲ. ಅದಕ್ಕೆ I may be permitted to treat hostile. ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ. He has spoken to or given evidence on all material aspects of the case of the facts that are well within her knowledge. If it becomes necessary, I will do it. Even if she is hostile when she says, don't grant it. No, merely because you are hostile, therefore I am rejecting your application. Your objection.
No, the accused number 15. Accused number 15 is Vinay Kulkarni. Now the conversation is not with Vinay Kulkarni.
No.
It is to give evidence against Vinay Kulkarni.
Yes. That is with a lady. A conversation between A1 and a lady.
All right.
Well, my learned friend said the victim has turned hostile. Right? That's what he said. No? But they have given him up. She appeared before the court. She wanted to give evidence of the additional charge sheet came to be filed. After statements came to be recorded, the prosecution would say, no, we are going to give her up. I shall read to you, Lordship.
Don't worry.
Well, at the first instance, when the trial took place before Dharwad court,
That is before the CBI.
yes, my lord, before CBI, she was treated hostile by the prosecution. My lord, the whole evidence that was recorded or collected by the investigator has been turned topsy-turvy now. because the CBI has collected evidence which is total contradiction to the evidence that has been given and led in court by the prosecution and collected by the investigator. Now we are only concerned with the evidence which the investigator has collected under 173(8 now.
Yes.
Now she appears. Summons was taken. The learned judge would also record time and again that cross-examination of this witness would be deferred because she is going to speak to the motive aspect and the conspiracy that is involved in the case, subject to the other witnesses or one or two witnesses who are going to speak to this very same. That is how, my lord, her examination was deferred from time to time despite the fact that she appeared before the court. Finally, on the last date of hearing, when she appeared before the court, the prosecution would make a categorical statement which came to be recorded by the judge. Shockingly, you don't want to examine her, you want to give her up. Yes, they say. That has been recorded. Where is the question of treating her hostile now? Where do you get that information? I'm posing that question to my learned friend.
You will answer it later. Yes. Next.
Well, at 164, I'm sorry, this pendrive, not even adverted to, not even referred to in the order. Even with regard to its production also, it has, well, he may accept it, he may not accept it. That is a different issue. That is left to his judicial.
But pendrive should have been referred.
At least she ought to have referred to it. When I say something, look here, he is a blackmailer. He is trying to make capital out of the situation. He would demand about 10 to 15 crores in order to see that I would not step into the witness box to give evidence against him as an approver. That's all. And he would place a demand upon a politician who is my political adversary. He will tell him, you tell him that he has got to pay the money. Otherwise, I'm going to keep quiet. But whatever it may be, for whatever worth it is, a certain material object, if my lord were to call that pendrive as a material object, or a document, in fact, how the Supreme Court has said in Akbar's case and all that, even a recorded version is also a document under 200, yes, under 206, 203, 209, that those things have also got to be given because it has the status of a document, even a pendrive and all that. But I would have been happy had he referred to it at least in that, which he does not do it.
Yes.
So the third legal submission. May I invite your lordship's kind attention? So before I take your lordship to the facts, I'm just narrating the legal submission. Though your lordship would be coming across time and again, day in and day out, Lord section 306 and 307 and 308. But just to refresh my memory, may I invite your lordship's kind attention?
Yes, sir.
True.
But
my lord also would be telling us every now and then, if you keep reading, every time you read, something new or the other will occur to us. That is how your lordship will be telling us every now and then. May I request your lordship to kindly...
New dimension at every read.
In fact, I don't know how your lordship would recall to your lordship's memory when I was arguing that matter under section 207 and 217 of the IPC. My colleague who is the counsel on record, Swamini, pointed out that I invited your lordship's attention in that case. But sometimes what may occur to us may not occur to others. What may occur to others may not occur to us. May I request your lordship to kindly have a look at section 306 for a second?
Yes.
Because it is a most serious and important issue. And I am covered by any number of judgments of the Supreme Court. Your lordship may take it any number of judgments.
Yes.
On this score alone, this order has got to go. This order has got to go. But since my lord has told us, my lord, across the bench and the bar, that this time no order of remand and it will reach its finality in this court only.
Well, if I have to do it, I have to do it. I can't do it. I can't do the job of the sessions court.
In spirit. Nothing, I mean nothing, my lord.
Right.
Can you go to section 306 now for a second? With a view to obtaining the evidence of any person supposed to have been directly or indirectly concerned in or privy to an offence, to which this section applies. The Chief Judicial Magistrate or a Metropolitan Magistrate at any stage of the investigation or inquiry into or the trial of the offence, and a magistrate of the first class inquiring into or trying the offence at any stage of the inquiry or trial may tender a pardon to such person on condition of his making a full and true disclosure of the whole of the circumstances within his knowledge relative to the offence and to every other person concerned, whether as principal or abettor in the commission thereof. This section applies to any offence triable exclusively by the court of. But a plain reading of the provisions of section 306 would indicate or tell us that this is a jurisdiction that is clothed upon the magistrate. A plain reading. Now kindly go to section 307. Power to direct pardon at any time after the commitment of a case, but before the judgment is passed, the court to which the commitment is made may, with a view to obtaining it, the evidence of any person supposed to have been directly or indirectly
Sessions
concerned-
Court.
a Sessions Court jurisdiction. Now, my lord, 308. This would be very, very important. Where in regard to a person who has accepted a tender, but first, an order that I am going to treat you as an approver. Then the second is, I am going to give you pardon. The third is acceptance of pardon by the accused whose application came to be allowed, without which, my lord, the process does not get completed. The whole thing goes. That is what the Supreme Court has said. My lord, why?
No, I considered this on the last occasion.
That is how your
This
lordship
argument
granted
was made, but
that is how your lordship
go
granted
deep into it.
Your lordship granted an absolute stay. But otherwise, what happens
There is a
this?
procedure
Yes.
after acceptance of pardon.
But otherwise, what happens is this.
That's what I interim model ಹೇಳಿದ್ದೀನಿ.
Yes, but that is how your lordship has granted an interim order. But otherwise, what happens is this. Well, my lord, a person against whom, my lord, a serious acquisition or charge is made and whose culpability is more when compared to others, my lord, would come out with an application and makes an application and seeks for pardon, and that application is allowed. In fact, it has happened in this case also with regard to the other accused. He was given the pardon. His 164 statement was recorded. The judge had not recorded his evidence. 164 statement had been recorded. Then he was summoned as a witness. He turned hostile. But then what is it that the court could do? The
That is
court,
why 308
308.
is important.
then, my lord, then only, my lord, after reference to the High Court, my lord, he could be prosecuted. That is a safeguard. That is a safeguard. Otherwise, he gets virtually the benefit of a judgment of acquittal at the initial stage or an order of discharge at the initial stage. Virtually, it is in parameteria with an order of discharge. He being pardoned, look here, step into the witness box, I am going to treat you as a witness, means he will be enjoying the benefit of an order of discharge as against the other accused who are required to take the trial in the case. That benefit continues, still he turns hostile. In the absence of an acceptance of pardon by him. In the event of there being acceptance of pardon by him, there could be a prosecution against him under section 308. Otherwise, no. Just kindly permit me to take your lordship. Where in regard to a person who has accepted a tender of pardon made under section 306 or section 307, this 308, has got to be read along with the 306 and 307 with regard to the acceptance of pardon, because we don't get either under section 306 or under section
No, I
300.
mean to say, after 307 order is passed, tendering pardon,
Yes.
that should be made over to the person who
My lord,
is
How-
wanting to seek pardon. He should accept the pardon,
kindly,
and then the statement should be recorded is the submission that you are making.
Lord, kindly pardon me for a minute. What the Supreme Court has said, is, no sooner his application is granted, send a copy of that order to the accused, then ask him whether he is going to accept the pardon or not. If he accepts the pardon by filing an appropriate affidavit or a memo, whatever it may be, then proceed to record his evidence. Otherwise, no.
One clarification.
I'm sorry.
Now, when he files an application supported by an affidavit or whatever, saying that I am going to turn approver and please grant me pardon, would that not suffice that he would not deviate from his
No, my lord.
his
See,
affidavit that he is saying
the
he's
question
wanting
of
pardon?
the cost.
Is it tacit compliance with the 308 or there should be a 308 compliance later?
The question of acceptance of a pardon would arise or step in only after the court says,
of
I am going
pardon.
to pardon you. Without pardoning him, how could he say, I am going to accept the pardon?
The affidavit may result in pardon, may result in rejection of pardon.
Rejection also. I will say, sorry, I am not interested. I will go and stand in the dock itself. I feel I am in a better position in the dock rather than in the witness box.
So,
I mean, that too, my lord, when 308, after imposition of conditions,
correct.
those conditions he has got to accept. Prior to the passing of the order, he was certainly not aware of the conditions.
If the order under 307 itself speaks of conditions and all that, is it again
Well,
to be ordered? No, I'm
307 or 306 does not postulate any imposition of condition.
postulate.
No.
But while the judge passes an order under 307, if he
He'll be-
imposes 1, 2, 3, 4
He will be
conditions,
overstepping.
no, that's what I'm
He
just
can't
clarifying.
overstep. But he can't
clarifying
overstep the
my
mandate of
doubts
law.
also.
It will be an assault on the provision. He can't overstep the mandate of law.
That's all.
Yes, no, that is my
No,
submission.
he may not refer to 308.
Poetry.
But if he says these are the conditions on which I am granting pardon without reference to 308, would that suffice to come to obviate the procedure under 308?
But he should say that then. It is not for the
If
court.
in a given circumstance.
Yes, it is not for the court. Ultimately, it is for the accused. He should appear before the court no sooner the order is passed, no sooner the conditions are imposed. Yes, I am agreeable for this condition. I am accepting the pardon. My lord, I shall invite my lord's attention to the Supreme Court. What the Supreme Court would say is, you send the copy of the order to him. And of course, my
So
lord,
just clarifying.
please. May I now kindly
ಮೊದಲೇ
have
ಕ್ಲಾರಿಫೈ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ಆಮೇಲೆವರೆಗೂ ಇರಲ್ಲ. Yes.
Well, it is only under 308 that we get the imposition of conditions, not in 306 or
So
300.
306, 307 is a plain power
That's it.
of the magistrate in a sessions court to grant pardon or reject pardon.
Okay.
Once pardon is granted, 308 kicks in.
Okay.
That's all. Yes.
May I request your lordship to kindly go to the order and the proceeding sheet again. And I am only making my submissions on the important legal issues which I have raised.
Yes.
Well, at page 121 is the operative portion of the order.
Yes.
Order that is available on record.
Again, with permission to digress, ಎಲ್ಲೂ demolitions ಇದೆ. I'll just grant them stay and continue. Yes. I'll continue.
ಅಲ್ಲ, ಇದು-
ಧಾರವಾಡ ಬೆಂಚ್ ಸ್ವಲ್ಪ ಮ್ಯಾಟರ್.
230 more list?
ಒಂದ್ ನಿಮಿಷ ತಾಡಿ. ಏನ್ ವಾಪಸ್ ಹೋಗ್ಬೇಕಾ? ಬೆಂಗಳೂರು ವಾಪಸ್ ಹೋಗ್ಬೇಕಾ?
ಇಲ್ಲ ಇಲ್ಲ
ಹಾ, ವೇಟ್.
ಅವರೇ ಕೇಳಿಸ್ಕೋಬಹುದಲ್ಲ, ಅವ್ರ ಹತ್ರನೇ ಇದೆಯಲ್ಲ.
ಅಲ್ಲ ನನ್ಗೆಲ್ಲ
Vote ಕೊಡ್ತೀವಿ ಸರ್, ನಮ್ಮ ಕರ್ತವ್ಯ. I sought, my lord, I said yes, it is a lapse on my part. I may be the lapse may be
ಯಾವಾಗಲೂ
condoned.
Pendrive ಕೊಡ್ಬೇಕಾದ್ರೆ ಟ್ರಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಕೊಟ್ಬಿಟ್ರೆ ಇಟ್ಸ್ ಈಸಿಯರ್.
ಅಲ್ಲಲ್ಲ, ಈಗಿನ ಕಾಲದಲ್ಲಿ ಏನಾಗಿದೆ, ಟೆಕ್ನಾಲಜಿ has advanced to such an
I can
extent.
myself do it. That's a different thing,
ಅಲ್ಲ.
but that's not correct.
Sorry, that is right, my lord. As
Unless the transcript
No,
is
no,
there, I
that's
would
right,
not
my lord.
venture
No doubt,
it.
as the learned judge, I have a laptop, therefore I myself can type it ಅಂತಂದ್ರೆ, ಆ ಮುಗ್ಧ ಹೇಳೋಕ್ಕಾಗತ್ತಾ? ತಾವು ನೋಡ್ಕೊಳ್ಳಿ.